Good morning, everyone, and thank you for joining us for today's Employment Law Basics for Small Businesses with presenter Christina Tamaino. This is the second part of the series, Best Practices for Navigating Employment Relationships. This program series is a partnership between the Barry Public Library and the Small Business Center. My name is Modupe from the Barry Public Library. I would like to introduce my colleague, Caitlin, from the Small Business Center. Caitlin will be taking care of tech and questions in the chat window. The presenter will take questions in the chat during the presentation, so you can put them in at any time during the presentation. I would like to welcome our presenter, Christina Tamaino. Christina is a labor and employment lawyer practicing at SV Law. Christina advises on a broad scope of labor, employment, and human rights issues, including employment standards, grievance arbitration, collective bargaining, and workplace accommodation. She provides strategic guidance in navigating complex workplace issues and implementing sound workplace policies. Christina is also an experienced workplace investigator and regularly assists both unionized and non-unionized employers in responding to allegations of workplace harassment, violence, and discrimination. I will now hand it over to you, Christina.
Thank you so much, and good morning, everyone. First, I'd like to thank the Small Business Center and the Barry Library for having me. I'm so excited to be here. And I'm so excited to have all of you here for our second series on employment law basics for small businesses. Today, we'll be discussing best practices for navigating employment relationships, and we'll touch on some of the common pitfalls for employers that come up during the course of the employment relationship. I hope some of you were able to join us last month for best practices for implementing employment relationships. I understand that recording is available if you weren't able to join us. And next month, we'll be chatting about best practices for ending employment relationships. All right, so I just have the agenda up. So the three key issues we'll discuss today are progressive discipline and performance management, workplace accommodation, and workplace harassment. Now, I have indicated that questions and discussion will be at the end, but I am absolutely more than happy to have questions throughout the presentation. We'll be covering a lot, so please ask away. I'd love to get some good discussion going. All right, so jumping right in to progressive discipline and performance management. Now, as an employer, as unfortunate as it may be, there are going to be circumstances where you feel the need to correct employee behavior in order to have the most efficient, effective, and productive workplace. Now, I often hear from my employer clients that they've spoken to an employee X number of times about an issue, and it just doesn't seem to be getting through to them, or they don't understand why, now that they've gone ahead and terminated, I'm telling them that they don't have a good case. And the reason for that is often because there's a lack of what's called progressive discipline. So progressive discipline is meant to correct poor or problematic behavior in a way that's fair to both the employee and the employer, that's predictable, consistent, and reasonable. Now, what this does is it gives you as the employer an opportunity to clearly communicate what it is you're expecting from your employees, the aspect of those expectations that is not being met, and what the consequences will be if the employee doesn't improve or change their behavior. By having all of those points clearly communicated and documented, it puts both the employer and the employee in a position for success, because it allows the employee to really understand what the issue is and hopefully address those issues. And for the employer, having well-documented progressive discipline is going to set that foundation if, unfortunately, you do need to proceed with a termination. And that's why I say I'll emphasize this a number of times through the presentation, a bit of a broken record, but the key is really to document every step of the way. I often, like I said, I'll have clients come to me and say, oh, well, we've talked about this 10 times, but there's no documentation to support any of it. And so it's almost useless if it comes to a wrongful dismissal claim. So the key is document, document, document. From the first discussion to the last discussion, make sure you're getting those records in place. And so the name progressive discipline suggests that there's going to be an escalation of corrective action in response to the performance concern. And so I've outlined some of the stages of progressive discipline that I would recommend that employers go through before they take a termination position in the event of employee misconduct or performance issues. So first, as you see, is coaching, and that's going to be the most informal of the stages, essentially speaking to the employee, saying, okay, these are the behaviors we've identified that are problematic, or these are the issues of your work performance that are lacking. And let's discuss what's causing that and what support you need in order to meet expectations. And that can give the employee an opportunity to raise any issues of their own. It may be that they're not understanding something. It may be that they need additional training, they need some supervision, or there may be something going on behind the scenes that may lead to, say, a workplace accommodation request, which we'll talk about in some more detail later on. But that initial coaching stage really gives both parties the opportunity to explore those issues in a manner that's non-confrontational, really meant to be supportive. Now, even though this is an informal stage of the performance management process, still be sure to document. Often what I recommend is you have the discussion and you follow up with either a letter or an email to the employee that just says, hi there, just further to our discussion today, confirming that these are the points that we discussed. Please let me know if you need further support or you'd like to discuss further. Just nice and simple, but you have that on record now if you need it. Now, if coaching is unsuccessful, you'll escalate to the verbal warning stage. And that's what I call the first level of the formal disciplinary process. Now, the goal is still to be supportive. It's still relatively early in the process, so you're trying to get the employee to improve their behavior and trying to identify what barriers might be in the way that are causing them to perform poorly. That said, the verbal warning puts the employee on notice that this is unacceptable, it's been noted, and this is what we're expecting. Now, what my clients often are confused about is I'll say, okay, there's a verbal warning. Is there documentation? And like I said, I'll be a bit of a broken record with this, but even with the verbal warning, I would recommend providing a letter to the employee to go with the warning that simply says, this is confirmation that you received a verbal warning on this date about X, Y, and Z, and this is what we've discussed. And that can be confusing to employees as they're saying, well, it's a verbal warning. Why am I getting a paper that goes with it? But it really is valuable for both parties, frankly, because it gives the employee a reference point as well. And if that's unsuccessful, that's when we really escalate things and we go to the written warning. And this is where you would sit the employee down, and the letter is not just a formality or a follow-up at this point, it is the disciplinary process. It's a written warning that says, this is the conduct. We've discussed it on X day when I provided coaching, X day when I provided a verbal warning. You have not changed your behavior, and therefore now we're going to a written warning. Now, this is about the most serious in terms of discipline that I would recommend for a non-union employer. Suspension, which you may have expected to see as the kind of the intermediary step between a written warning and a termination, can be tricky for non-unionized employers unless they have good employment contracts in place that allow for a suspension. So I tend to recommend you take the more cautious approach and just stick to a written warning. And often you can do, if there's a period of improvement or if there's a length of time between different aspects of misconduct or poor performance, you can give multiple written warnings. So there's flexibility here when it comes to the stages of discipline. But if you feel as an employer that you're getting to the end of the rope with an employee, what you want to be doing is in the written warning, clearly identifying that if the behavior does not change, their employment will be terminated. So they're on full notice, and you can proceed as you feel necessary. And finally, of course, if there is no improvement, it continues to be an issue, then proceeding with termination is kind of the culmination of the progressive discipline process. Now, often employers will ask me, okay, so we've done this disciplinary process. Can I now fire the employee for cause? And we'll chat about this in some more depth and detail in the next presentation on ending employment relationships. But what tends to surprise employers is that the threshold for a for-cause termination is extremely high. Even if there has been a series of disciplinary incidents that have been well documented, it can be difficult to meet that threshold. So my recommendation tends to be to terminate without cause unless the conduct is very egregious. And in the event that you are proceeding with a for-cause termination, I think there's absolutely value in chatting with counsel first, getting some guidance on how to navigate that process. Now, when it comes to progressive discipline, there's two real categories that an employer may want to address. The first is poor work performance. And there's a number of causes for poor performance. It can simply be incompetence. It can be a lack of training, a lack of resources, or simply a misunderstanding about the expectations of the job. So by clearly setting out the expectations, communicating those expectations to the employee, and allowing them time to improve and meet those expectations, you're really supporting your investment in the employee, because one of the largest resource drains for employers, frankly, is having to terminate and recruit new employees. It's an investment of time and investment of resources. Performance management is a way to prevent those losses and make sure that you are getting the most value from your employee and the employees having a successful experience at the company. And as I keep saying, keep detailed, complete, and dated written records. Whether it's poor performance or outright misconduct, make sure you have that file and you're keeping it up to date. And now the second area of potential disciplinary concern would be employee misconduct. So this is the more traditional disciplinary action where the employee has done something that is contrary to your workplace policies, contrary to health and safety, what have you. Now, dealing with employee misconduct is more difficult at times than simply dealing with poor performance. The important thing, again, is to give the employee the opportunity to explain themselves after you've clarified expectations, why the conduct was contrary to the expectations. And you'll want to collect all the relevant facts about the alleged misconduct. So that means is when did it happen? Where did it happen? How did it come to your attention? Were there any witnesses? It may be necessary to interview those witnesses depending on the severity. So towards the end of the presentation today, we'll talk about workplace harassment and the importance of an investigation in that context. But really getting all the facts, giving the employee the opportunity to respond to those facts will put you in the best position if you need to act on the discipline. And I know I've outlined a kind of 4-step progressive discipline process, but I want to emphasize that it's not necessary to stick to that rigidly. In certain situations where there is severe misconduct, it may be necessary to skip straight to a written warning or frankly skip straight to termination. So it will always need to be assessed on a case-by-case, fact-specific scenario before going ahead and just rigidly applying the progressive discipline scale. All right, so before I jump into the duty to accommodate, it might make sense to take a look if there's any questions, and I see there are. All right, so Celeste asked, for documentation, is it enough to basically journal the date and what happened? Or does documentation mean written proof of the conversation, which is provided to the employer and the employee? That's a great question. The answer may be a bit frustrating. It's effectively either can work. My recommendation would be to provide a formal correspondence to the employee so they have that in their records. And in the event that you need to act on the discipline, say you do end up in the situation of a termination, then the employee can't turn around and say, well, you've recorded something that didn't happen, or I have no record of that happening. So I do think that there's value in providing that documentation to the employee for the more substantial steps. So for example, if it's a verbal warning, a written warning, making sure they have those documents. If it's something like you've had a preliminary coaching chat, you've had some discussions about expectations, in that case, I think detailing for yourself in your own notes that the conversation occurred, this is the time and date of the conversation, this is the content, is perfectly fine, and there's no need to provide that to the employee. And Teresa's got a great question too. It's what if an employee on probation doesn't show up for their scheduled start time? So that's a great question, and that can be that you have more flexibility there if the individual is in their probationary period. So if it's tardiness that's reoccurring and they're early in their probationary period, what I may say to them is, okay, we've noticed that you're not arriving for your scheduled start time. We want to make clear that this is our expectation, and that if this continues to be an issue, you're not going to be successful in your probationary period. That's what I'd call the more cautious approach. When it comes to the probationary period, it's really meant to allow employers to assess the employee's suitability for the position. So I often hear, oh, well, there were some issues in the probation, but we thought we'd give them a chance, and then you're dealing with the problem kind of years later. So depending on the other factors at play, whether they're performing well otherwise, whether you'd like to continue the employment relationship, or you think that this really isn't the right fit, you can simply go ahead with a termination if you feel it's necessary. And in that circumstance, I wouldn't necessarily disclose, or in fact, I wouldn't disclose that the tardiness is the reason for the termination. I just say, in accordance with our probationary approach, we've assessed that you are not suitable for this role. All the best in future. And just keep it simple. So Teresa has another good question, and Celeste as well, and I'll answer them kind of in one. So Teresa's asking if she has not had an employee contract reviewed and didn't give the updated contract to the employee, can they still provide that during the probation period? And Celeste is asking, is the probation period always 3 months, or can it be any length of time? So for the contract issue, my recommendation is always that a contract should be provided before the employee starts on their first day. and they should be given a reasonable period of time to review its contents. If you're going to provide them with a contract during the probationary period, what I would do is either provide them with a small signing bonus to sign off on the contract, or give them notice that the contract is going to come into effect in a period of time. And when it comes to the probationary length of time, you can certainly have the time period be upwards of 3 months, up to 6 months, or even longer, depending on the nature of the employment. It's important to be mindful, though, that under the Employment Standards Act, the 90-day, 3-month probationary period is the only time period where an employee is not entitled to termination entitlement. So on paper, you can say, yes, your probationary period is 6 months, but if you terminate between months 3 and 6, you will owe termination entitlement. All right, so jumping into the duty to accommodate, this is what I would call the most frustrating aspect of being an employer when it comes to navigating those challenges in the employment relationship. So the duty to accommodate, as you may know, is related to the Human Rights Code, and employers have a duty to accommodate the protected characteristics of employees up to what's called the point of undue hardship. And this is broken down into a procedural duty to accommodate and a substantive duty to accommodate. A failure on either of those elements can lead to an award against the employer at the Human Rights Tribunal. So it's important to be familiar with your obligations under the code and to have some good policies and procedures in place in the event that an employee does need accommodation. So I've listed out here the protected grounds under which an employer may be required to provide accommodation. In practice, I would say that you're most often going to be dealing with disability and family status. The other protected grounds don't necessarily come up in the context of workplace accommodation, but certainly something to be mindful of as a protected ground. So when it comes to the procedural duty to accommodate, this essentially means that if an employee comes to you as the employer and says, I need an accommodation, or I can't do X, Y, Z because of my disability or my childcare obligations, then you as the employer have an obligation to ask the right questions, to ask about the employee's accommodation needs, obtain documentation, and that can be documentation from their treating physician, and conduct an assessment of what accommodation measures can be provided in the workplace. So that may be anything from an earlier start time to allow someone to meet their childcare obligations, or a standing desk if an employee has a disability that makes sitting difficult. So the key will really be providing that individualized assessment, and applying a one-size-fits-all approach will not be successful if you need to defend your accommodation efforts at the tribunal. So I always like to emphasize that a procedural failure on its own is enough to lead to damages under the Human Rights Code, even in circumstances where it would not have been possible to provide an accommodation. So it's always key, if someone is coming to you and saying, I need this accommodation, don't dismiss it out of hand. Make sure you're asking questions, you're getting the right information. Often I'd say that the duty to accommodate is another area where I would recommend seeking the help of counsel or an HR consultant. Can also be very helpful in navigating the issue because it can be quite challenging. Now, when it comes to the substantive component of the duty to accommodate, we're looking at the reasonableness of the accommodation. So once you've gone out, you've asked the employee, okay, what's the issue? What do you need? You've access to documentation, you've reviewed it. Now the onus is on the employer to consider what accommodations can be provided. And you'll need to be able to demonstrate the considerations you took, the assessments you made, and the steps that were taken to provide appropriate accommodation. So I often hear from employers that, oh, that's going to be too onerous to provide their accommodation, or if I provide this accommodation to them, the rest of the workplace is going to be unhappy. Those considerations are always secondary to the accommodation needs. And you're not required to provide someone with a perfect accommodation. It doesn't have to be their preferred accommodation. What it needs to be is an accommodation that's reasonable in the circumstances in light of the information that you've gathered during the procedural stage. And as I mentioned, the duty to accommodate does have a limit, and that's what's called the point of undue hardship. And this is a legitimate reason for employers to say, I'm sorry, we simply cannot accommodate you in the workplace. And it needs to be a significant difficulty. It can't be mere inconvenience. It needs to be something quite substantial that would fundamentally impact the employer's operations. So under the Human Rights Code, what the tribunal would be looking at is, for example, workplace safety, the size of the employer's operations. A mom and pop shop is not going to be held to the same standard as, say, Amazon, and the cost of the accommodation. Now, what I will say is cost tends to go in the employee's favor. The cost has to be quite high in order to be seen as a barrier to successful accommodation. And as with performance management and progressive discipline, an individualized approach is key to determine whether undue hardship exists and whether you can accommodate an employee's disability or family status related needs. This is another area of, I'll say, employment challenges where documentation is absolutely critical. So right from the start, if there's a request for accommodation or you become aware that an employee may need accommodation, start documenting, start the file, and keep track of everything that you've asked, everything that you've done, and the response that you're getting. What I often see is an employer will come to me and say, this person has been off work for 2 years. I'd like to terminate them. And what they'll show me is a series of doctor's notes that all say, employee needs to be off work for medical reasons. And the employer didn't push. They just said, all right, their doctor says they're off work for medical reasons. Or the doctor says, this person can only work the day shift for medical reasons. That is not sufficient necessarily to establish that that is the appropriate accommodation. So what I always tell employers is, don't be scared to ask more questions. If something seems incomplete or you're not being provided with all the information, within reason, you are permitted to ask for more details. So in the example of an employee with a disability, you can't ask for the diagnosis or specifics as to their medical condition, but what you can ask is things like, what restrictions do they have specifically in relation to their job description? And I often provide job descriptions to their doctors so they can review and provide comment. Things like, are they complying with the recommended course of treatment? What is the expected duration of their treatment? And how long do we expect to need these accommodations to be in place? That's all reasonable information for an employer to have and is necessary for you to assess whether that point of undue hardship is met. Now, if the employee resists or refuses to participate in the accommodation process by providing you with this information, that may be a failure on their part and can result in a finding that the employer did all they could and the employee was the one who caused the accommodation process to fail. All right, so again, before jumping into our next section, I'll take a look and see if we have any questions, and I see that we do have a few. All right, so Teresa asked, can these types of questions be asked in an interview before hiring? She's had potential employees ask for accommodations. Is this acceptable? So I typically would not recommend asking if they need accommodation in the workplace during the initial interview. What you can do is in your, either in your job posting or in your correspondence with the employee regarding the interview, simply state, we are willing to provide accommodation if necessary for you to participate in the interview, so please let us know. In that sense, you are meeting your obligations under the Human Rights Code by providing accommodation if necessary, but you're not prying in a way that an employee or potential employee may find to be offside. And the important piece there is that human rights obligations related to employment also relate to potential employment. So if, for example, you ask in an interview, oh, well, do you need any accommodations? And the employee says yes, and they tell you, oh, I have a disability, I can only work between the hours of 9 and 3, for example, and you opt not to hire that employee, there is some risk that the employee may claim under the Human Rights Code that the reason they were not hired is because they disclosed a disability to you, and then the employer may be facing liability. So I'd be careful with that one, but there are ways to do it without looking like you're prying. All right. And before we jump into the workplace harassment piece, one final note on the duty to accommodate is if you are a unionized employer, and I expect that most of our attendees today are non-union, but in the event there are any unionized employers here today, it's important to get the union involved in those discussions and have them participate in identifying an appropriate accommodation. So just as in a non-union relationship, accommodation is a two-way street between the employer and the employee. If there's a union involved, then it becomes a three-way street effectively. Okay. So jumping in to preventing workplace harassment. And I would describe this as the third real pitfall that employers can run into is navigating complaints of workplace harassment or violence and responding to those complaints. So all employers under the Occupational Health and Safety Act are required to have a workplace harassment policy, and that's regardless of the size of the workplace. Employees should be made aware of this policy. They should be familiar with this policy. And the reason that I've put this last in the presentation is because a failure to respond to a workplace harassment complaint appropriately may lead to any of the types of liability we've already discussed today. So either a human rights application, a claim for constructive dismissal, or even a complaint to the Ministry of Labor. So it's really something to be diligent about. And I've included here for your reference, I won't go through them all, but the elements that a good workplace harassment policy should have. And just like all workplace policies, it's really going to be the bedrock for employers in responding to issues that arise during the course of employment, because it's something you can point to and say, okay, these are the steps we're going to take. These are our expectations. So just like performance management and progressive discipline, having a clear, consistent, and fair response is going to be key. Now, the important takeaways from a workplace harassment policy are making sure that there's a procedure for reporting harassment, that there's information about how a complaint will be addressed and investigated, and that there are procedures for ensuring that an employee can report harassment of their supervisor. So if the policy says, well, bring any complaints to your supervisor, but the supervisor is the alleged harasser, that's going to be a problem. So there needs to be a mechanism that employees can escalate a complaint to a higher level. Now, this is the area where most employers have some difficulty, and that's with workplace harassment investigations. So if a complaint of workplace harassment is made under the Occupational Health and Safety Act, an employer must ensure that an investigation is conducted that is appropriate in the circumstances. Now, there's not a lot of guidance provided by the legislation on what constitutes appropriate in the circumstances, but I've included some best practices for employers in that situation. So for example, the person who investigates should not be involved in the incident and should not directly report to the alleged perpetrator of the harassment. And that's just for procedural fairness reasons. Now, what I often see is employers will come and they'll tell me, I received this harassment complaint. I don't think there's anything to it. I talked to the person and that's it. That's not going to be sufficient. So at the minimum, you'll need to interview the employee who's complained and the employee who they've complained about, get their side of the story, and make a determination as to whether you feel there has been misconduct in the circumstance. Depending on the severity, a more fulsome investigation may be necessary, involving witnesses, documentation, reviewing email correspondence between the parties. It will, as with accommodation and performance management, really depend on the facts of the individual scenario, and it needs to be assessed on a case-by-case basis. This is another area where I would recommend seeking help if you need it. Workplace investigations can be quite complex and quite fraught. So I would absolutely recommend speaking to someone who specializes in workplace investigations. There are some great HR consultants who are very well versed in responding to workplace harassment and ensuring that there is reconciliation afterwards, especially in a small workplace. I know we're talking about small businesses. It can be difficult if you have, say, 5 employees and one of them has made a harassment complaint against another. That's going to cause some problems in the workplace harmony. So making sure that the investigation process is conducted in a way that's fair, that allows both parties to feel that they've been heard, and that has a clear response and conclusion is going to help in that process. So there needs to be a written confirmation of the results of the investigation, and that needs to be provided to both the employee who complained and the employee they complained about. And as always, documentation is key. So I've indicated there some of the key facts you should make note of. And with investigations, it is more crucial than in almost any other situation to make sure that things are well documented. This is one of the rare situations where I would recommend taking verbatim notes of any discussion that you have with the employee, so that when you go and you assess whether harassment has occurred, you can do so with a clear picture of what both parties have said. All right, so I know that was a lot all at once. So I'd like to jump into some questions again and some discussion. And so great question. What if there's an anonymous complaint and the name of the complainant or the issue wasn't described? How do you properly deal with it? That's a great question. So when you are conducting a workplace investigation, one of the things that surprises complainants at times is that there does need to be a disclosure to the responding employee of the name of the complainant, the nature of the complaint, and the details of the complaint. And the reason for that is that the responding employee needs to be afforded the opportunity to make a full response to the allegation. If they're not afforded that opportunity, then there can't be a disciplinary action that will be upheld. Now, in the case of an anonymous complaint, I would still recommend doing some investigation to the extent that you can. But if you don't have a complainant and you don't have an incident that's been described, there's very little that you can do. So in that case, I would perhaps do some refresher training with your employees on your workplace harassment policy and on the steps for bringing a complaint forward, including the fact that it should be a formal complaint that includes necessary information, and that you love to act on the complaint. You want to fulfill those obligations. You want to be able to investigate, but you can't do so properly unless you have all that information. Now, if it's an anonymous complaint that does have detail, for example, the complainant isn't identified, but there's enough information for you to do an investigation, then I would act on that complaint and speak to the respondents and say, well, we've received an anonymous complaint and it's detailed X, Y, and Z. What's your response? It's more difficult, certainly, but there is still an obligation to treat those anonymous complaints seriously. Any other questions? I think I've answered all of the ones in the chat, but we do still have some time. So please, if there is anything else you'd like for me to answer, please don't hesitate to put it in either the chat or the Q&A.
Thank you very much, Christina. I would like to add some information regarding resources that we have here. So please take a moment to complete our feedback form, and the link is in the chat window. You can borrow books on employee selection, interviewing, and on managing employees from the Barrie Public Library, as well as download free employment contracts and human resource legal forms from Law Depot. I have shared the link to both our business databases and Law Depot in the chat window. The next learning lab is Employment Law Basics for Small Businesses, and it's part 3 of the best practices for ending employment relationships. This will be on April the 27th, same time, 10 to 11 a.m. In part 3, key issues regarding termination from employment, including strategies and best practices for limiting liability, will be discussed. Links for registration are in the chat window, and we have 2 of them. Thank you, Christina, for sharing your expertise with us on this topic today. A recording of today's session will be available on Small Business Center's YouTube page in the coming weeks. Thank you, SBC, for co-hosting with the Barrie Public Library. And participants, please remember to complete our feedback form in the chat window. Thanks, everyone, and have a good day.
Thank you so much for having me, and thanks everyone for joining.
Thanks, Christina.